everyone. Welcome at the Villa Meunier. My name is Anissa Belal. I'm the strategic advisor on IHL, and I'm organizing this talk. I'm very, very happy that the room is so full, and I'm sorry that perhaps there won't be enough seats for everyone. The talk shouldn't last too long, it's 1 hour. Just a few words about the IHL Talks. Those are events that the Geneva Academy are organizing every 2 months on burning IHL topics. The aim of the talk is really to discuss among us about policy issues rather, so we are aiming at the public made of diplomats, of policymakers, of people working in international organizations. So it's not necessarily for like an academic discussion, but rather a discussion aimed at practical results. We had already two, one topic on refugee, another topic on healthcare, this topic on counter-terrorism, and in 2 months we'll have another talk on the protection of cultural property in our conflict situation. So for those who aren't registered on the Academy newsletter, please do so. We will circulate like a sheet that we will put outside. I will say a few words about Ambassador Zellweger and Gunilla, and then I leave the floor to the panelists. So I will first introduce Ambassador Zellweger, who is the Swiss permanent representative to the United Nations office and to other international organizations in Geneva. Prior to this position, he was the director of the Directorate of Public International Law at the Swiss DFA in Bern, and he was also the head of office of the first serving president of the ICC. Ambassador Zellweger also holds a PhD in Public International Law from the universities of Neuchâtel and Basel. And Gunilla von Hall is a foreign correspondent in Geneva for the Swedish daily newspaper Svenska Dagbladet. She covers the United Nations, humanitarian affairs, refugee and migration issues and human rights. For more than 25 years, Ms. von Hall has reported on wars, conflicts and humanitarian disaster in more than 40 countries, including Iraq, Syria, Greece, Turkey, Bosnia, Rwanda, Honduras, Colombia, Iran, Sri Lanka, and so on. She has been published in the Swedish anthology The War and the Truth, and her stories have been selected for the anthology Good Swedish Journalism. With that, I think I leave you in very good hands, and I give you the floor.
Thank you. Welcome, all of you. This will be an interesting panel, and we will listen to our panelists, the ambassador, and afterwards we will open to the floor for questions. Would you like to start with a few words, please?
Okay, that was quick. Gunilla and dear colleagues, can I just abuse my position for a personal remark? As was mentioned, I was the Director of Legal Affairs until a few months ago in Bern. And we had a discussion with the Académie des Droits Humains for a long time, and then this idea of IHL Talks came up. And the big question was, is there enough of a IHL community here in Geneva? Mm-hmm. And some said, well, there may not be enough interest. We have a human rights community, we have a humanitarian community, but there is no community of IHL lawyers. And I think today all of those are proven wrong, and I'm really heartened to see that the turnout is so good. So I'm really pleased to be here and to be part of this series of IHL Talk. The topic of today's meeting, the impact of counter-terrorism laws on and policies on IHL and humanitarian action, is timely, and I don't think it will leave us soon. It will stay there, and I think it will be increasingly complex, and therefore I really welcome the fact that we will discuss it today. Counter-terrorism is nothing new. And counter-terrorism, or CT, responses and discourses have for some time already blurred the lines between armed conflict and terrorism, with potentially adverse effects on IHL. One can observe, for instance, a tendency among states to consider any act of violence carried out by a non-state armed group in armed conflict as being terrorism, even when such acts are, in fact, lawful under IHL. This results in a denial that such groups designated as terrorists may be party to a NIAC, a non-international conflict, within the meaning of IHL. Adding an additional layer of incrimination, the labeling of acts that are not prohibited under IHL as terrorist reduces the likelihood of obtaining respect for its rules even further. Let us be clear, armed conflicts and acts of terrorism are different forms of violence governed by different bodies of law. The legal framework governing armed conflict already prohibits the great majority of acts that would be designated as terrorist if they were committed in peacetime. The main difference is that armed conflict is a situation in which certain acts of violence are allowed or lawful, and others are prohibited or unlawful, while any act of violence designated as terrorist is always unlawful. Now, what does counterterrorism mean for humanitarian action? And I'd like to focus on this one aspect of the whole topic, not only knowing that my colleagues will address the other aspects, the relationship IHL and counterterrorism more specifically, but also because I think today this is probably one of the main challenges we face: humanitarian action and counterterrorism. Allow me to focus on this nexus, and we then go over to the other aspects. It's clear that in order to fulfill their obligations under international human rights law to protect the life and security of individuals under their jurisdiction, states have a right and a duty to take effective CT measures. While taking such measures, states must simultaneously ensure that humanitarian assistance is not criminalized and can be delivered according to the humanitarian principles of neutrality, impartiality, and independence. CT measures, whether at the domestic or international level, may, however, be interpreted or applied in ways that could impede humanitarian action. This risk is higher if the measures are drafted in an overly broad manner and lack clarity, even if this may be entirely unintentional. The consequences, this so-called chilling effect of vague rules, are increasingly known, and their effect is also increasingly known to those who issue them. The consequences can be serious. Some CT measures may result in the criminalization of core activities of humanitarian organizations and their personnel in the pursuit of humanitarian action required and encouraged by IHL. This can lead to dilemmas for principled humanitarian action, especially in relation to situations of armed conflict where non-state armed groups designated as terrorists effectively control access to or otherwise exercise power over civilian populations in need. Concretely, this can relate, for example, to visits and material assistance to detainees, to the facilitation of family visits to such detainees, to field first aid training, war surgery, or war surgery seminars. IHL dissemination in general may also be concerned. Assistance to provide for the basic needs of the civilian population in areas controlled by armed groups associated with terrorism, and large-scale assistance activities to internally displaced persons where individuals associated with terrorism may be among the beneficiaries. One notable example involves the provision of medical assistance to protected persons and civilians. Under IHL, humanitarian actors are guided by the principle to provide assistance to fighters hors de combat and civilians on the basis of need alone. We therefore see that CT measures may contradict existing IHL obligations and may run counter to the letter and spirit of the 1949 conventions and their additional protocols. Humanitarian space is needed by humanitarian organizations to carry out their neutral, independent, and impartial activities. What can be done? At the international level, some steps to address this issue have been taken. Discussions on the draft comprehensive Convention Against International Terrorism, you know, the convention that has been negotiated for quite a while. I think we started in 2000 and it's still under negotiation. These negotiations have focused on the exclusion of its application, of the application of the convention to acts governed by IHL. If you look at all these, I think there are 12 counter-terrorism conventions. Most of them contain a clause excluding IHL for their application, and the issue came up again in this comprehensive convention, and it could not be solved until today, and it's one of the main stumbling blocks to resolving the convention, which otherwise is almost negotiated. Furthermore, most UN CT resolutions require member states to ensure compliance of CT measures with all their obligations under international law, in particular international human rights law, international refugee law, and international humanitarian law. This clause is very important to Switzerland because we firmly believe that only CT measures that comply with international law can be effective. International CT measures must therefore be designed in a manner as not to recast humanitarian activities as unlawful support for terrorism and for groups or individuals designated as terrorists. Their implementation at the national level must respect the existing international framework to ensure harmony with policies and legal obligations of the humanitarian realm. To that end, we consider that a dialogue between humanitarian actors and CT actors should be promoted to ensure that people are sufficiently aware of the concerns and the challenges of the humanitarian community. Switzerland engages in many ways to discuss potential dilemmas of the intersection between CT measures and humanitarian actions and to find ways to mitigate them. We have organized a number of events in New York, in Geneva, and elsewhere, and we have made concrete proposals in relevant resolutions by the UN General Assembly and the Human Rights Council for preserving humanitarian action from negative impacts of CT measures. And you could imagine that it's not always easy because there is a growing support for CT measures, and to recall the importance of existing legal obligations in certain contexts is not always a given. In July 2016, these efforts have resulted in UNGA, UN General Assembly Resolution 70/291, entitled the United Nations Global Counter-Terrorism Strategy Review. In that resolution, you will find the following language: urging states to ensure, in accordance with their obligations under international law and national regulations, and whenever international humanitarian law is applicable, that counterterrorism legislation and measures do not impede humanitarian and medical activities or engagement with all relevant actors as foreseen by international humanitarian law. At the level of humanitarian actors themselves, some organizations explore the potential of exemptions. The basic idea is that a humanitarian exemption, if suitably crafted and prudently applied, would preclude the otherwise applicable counterterrorism-based liabilities from attaching to principled humanitarian action. The larger question of whether humanitarian exemptions are desirable and feasible implicates an array of cascading concerns that merit scrutiny from various perspectives. You see, we're just at the beginning, probably, of a longer reflection and a complex reflection. As I mentioned at the outset, we see this as a timely and pressing concern and will continue engaging in this field in favor of the respect of IHL and the defense of neutral and impartial humanitarian action. Thank you very much, and I look forward to our exchange.
Thank you very much, Mr. Ambassador. Let me just add something very quickly. As I'm a journalist and I've been covering lots of conflicts and wars in the field, I just want to give you a couple of examples of when I've seen this dilemma. First of all, I woke up this morning to see that Trump is now open to have waterboarding, which is, really a problem for many of us, I think. But I can give you an example when I was in Kobani, which is on the border between Turkey and Syria. and people were flooding out of there in the September of 2014, and there were injured soldiers, and they went to the hospital in Suruç, and Turkish doctors refused to operate on them, to treat them, because they were Kurdish fighters. And for them, Kurds, PKK, terrorists. Dilemma. So they died. But they treated ISIS fighters instead, which was odd. Same thing I saw in the Greek islands when the refugees came over in summer of autumn 2015. They came from Syria. In these refugee floods, some of them are also ISIS fighters. We know that. And also so does some of the NGOs on the islands in Greece and Samos, where I was. So when they lined up to get food, some of the NGOs, local NGOs, said, no, we're not going to feed them. Women and children, yes, we give you sandwich, milk, apple. Men, out. No food to you, you're terrorists. So this is what we see in reality. Now you have another view because you have a legal view, which I find very interesting. And I want to introduce you first. Carla Ruta, who works as a thematic legal advisor at Geneva Call. Before, she's worked with Geneva Call as a program manager for Colombia for 2 years. For more than 7 years, she also worked as a delegate for the International Committee or the Red Cross, ICRC, in Colombia, Gaza, and Sudan. Sandra Krenman, she's a research fellow at the Geneva Academy of International Humanitarian Law here, and she conducts legal research on the impact of counter-terrorism on human rights law and international humanitarian law. Especially, you're focused on the so-called foreign fighters phenomenon that we are all quite worried about in most Western countries now. And you have written a series of articles on these topics. Now, if we start with you, Sandra, how would you say that international humanitarian law address terrorist acts? Is there a definition of these acts in international law?
Well, I mean, this question has like two parts. So there is the definition, and then how does IHL treat such acts? So I would like to start with the first part, because I think it then makes it easy to understand why and how IHL deals with terrorism in the way it does. The short answer is, and Ambassador Selberg already alluded to that, there is no generic definition of what is terrorism in international law. There are still ongoing negotiations for having a comprehensive treaty on terrorism, and one of the main obstacles there is precisely to find such a generic definition that would cover all sorts of acts. So one part of the problem is how would it regulate its relationship with IHL, but you also have other problems. What would be the distinguishing feature of an act of terrorism as opposed to a regular criminal act? Would it be the political motive? Would it be that it targets innocent bystanders? Does it necessarily require to have an international element, or could it be a purely domestic act? Or what would be the interests to be protected? Would it only apply if there is death or serious bodily harm, or would we also cover property? And then this may have impact on, for example, freedom of assembly. If there is serious property damage, that could then be covered. So there are many problems with having a generic definition. What we do have is a series of UN conventions that look at specific acts of terrorism, like hijacking of aircraft, hostage-taking, and more recently some broader ones that look at terrorist financing or terrorist bombings or nuclear terrorism. And we also have regional conventions, and some of them actually do have a general definition, but that's very much specific to a regional context, and then they frame the exclusion clauses in a way which would be difficult on a universal level. So we do not have something generic in international law per se. Then if you look at IHL, so I think every act that we would normally consider to be terrorist is prohibited under IHL. IHL prohibits the deliberate and direct attack of civilians, it prohibits hostage-taking, aircraft hijacking is less frequent in armed conflicts, but it may still happen, but it does prohibit these acts. It does not necessarily label them as terrorists, but they are prohibited under IHL. And what IHL also does is that it organizes the repression of these acts at least most of them, as war crimes. So there is a way that perpetrators of such acts can be held accountable under international laws. There's no impunity for acts of terrorism under IHL, even if they are not called terrorism necessarily.
What would you say is the interaction between international humanitarian law and these other conventions?
Well, before I talk about, which we have already addressed, the legal interaction is the question of the exclusion clauses. But I think the problem is that we have a lot of groups that are party to a non-conflict that are also designated terrorist organizations. I mean, the prime example is precisely the group that calls itself Islamic State. They are designated terrorist organization, but they are also a party to a non-conflict. Just by being designated a terrorist organization, that doesn't matter for IHL per se. You can still be an armed group to that conflict, and your actions are governed by IHL. And in IHL, you know, many acts of violence are unlawful, especially acts of violence against civilians. But some acts of violence are also lawful. It's like attacks against military objective. Even if you undertake that attack as a member of a designated terrorist organization within an armed conflict, if it's against a military objective and it's proportionate, that's an act that is lawful under IHL. But under a terrorist convention, like the terrorist bombing convention, that very same act would be unlawful and it would be a terrorist offense. So if you apply this convention in an armed conflict setting, then it would outlaw acts that are prohibited by IHL. And that then, in a comprehensive convention, that could apply to other acts like medical activities or financing of such acts. And this is why we have these exclusion clauses. Where they say that these conventions do not apply to acts that are governed by IHL in a situation of armed conflicts by armed forces. So not everybody interprets these exclusion clauses in the same sense, but my view and many of people who deal with IHL, they say, well, for that to make sense and to make sure that IHL is not undermined, this means that the acts of armed groups in a context of an armed conflict remain governed by IHL and would not apply to these groups. So the convention wouldn't apply to these acts.
Whether you have situations like the Syrian army would bomb hospitals in Syria because they say we have ISIS terrorists hiding in the hospital. So they think it's a military target because our enemy is in there, but it's still wrong because it's a medical hospital.
Yes, you are under IHL, you're prohibited from attacking hospitals.
But in their mind, it is a military target.
Yes.
What would you say are the largest legal challenges raised by counterterrorism?
I think there's so many legal challenges, but we only have limited time. Now, I think I will speak about two. One, not specific to IHL. I think we need to be aware of that even in the context of an IHL talk, there are going to be significant challenges for human rights protection, because we have seen during the last 2 years the largest wave of new counterterrorism laws and policies, both on a national and international level. And these laws and policies, they graft on and they compound the effect of already existing measures and policies. And I think, just to give one example, like what is new, I think we see much more now a linkage between counterterrorism and control of borders and management of refugees and migrants. And I think the Special Rapporteur on Counterterrorism just did his report on that and how that can undermine refugee law and the protection of migrants and the very people who actually flee terrorist violence. You mentioned before, we have seen whether it's authenticated or not, the proposed draft executive order that would at least open the way to reinstate some of the most egregious policies that we have seen in the immediate aftermath of 9/11. So I think that is a significant challenge to roll back on human rights and some of the progress that has been made. More specifically for IHL, I think how do we make sure that IHL remains or is not undermined by counter-terrorism. And I think it's particularly important in the negotiations of the draft convention that the exclusion clause is drafted in a way that it is clear that the acts of armed groups, whether or not they are designated terrorist groups, are excluded from their scope of applications. And sometimes people ask, well, why is this so important? Why does it matter whether you bomb something in an armed conflict or whether you do not bomb something outside an armed conflict? It can be the same act, by the way, same group, but the context is different. And then why should there be a different legal regime? I think the reason is precisely because IHL does not prohibit certain acts of violence, and it relies on the fact that some acts of violence are lawful, and if armed groups then know whatever they do is going to be unlawful under international law in any event, that would undermine the incentive they have to actually comply with international humanitarian law. And we need to be aware of that. This doesn't mean that we are legitimizing or giving some kind of status to armed groups that are designated terrorist groups. IHL is very clear, it doesn't affect the status of these parties under national law, and it still allows for the prosecution of even lawful acts of IHL under national law. So there is no need to actually add an additional layer of incrimination on the international level.
Would you like to add something, Mr. Steinberger?
No, I'm fine. Perhaps at the end, but I mean, I think we fully agree.
Yeah, very interesting, really. Thank you, Sandra. Very interesting. Carla, what is the impact of counterterrorism on humanitarian action, would you say?
Well, first, thanks a lot, Gunilla, and thanks a lot to the Academy for inviting Geneva Call to this panel. Let me start maybe on a positive note to change and to say that actually there should be certain common goals between humanitarian action and counterterrorism, namely the protection of the civilian population. In theory, there should not be contradicting goals there. One could even go further or more in detail and say that another common thing is that humanitarian actors and counterterrorism measures want to prevent that, for example, humanitarian aid is diverted and serve a party to the conflict or military purposes. So in theory, there should not be necessarily an opposition if the CET measures do respect IHL and human rights law, and of course also if humanitarian actors act in a principled way. But we know that's the theory, and of course practice is a bit more complex. Let me bit also for time reason maybe limit a bit the scope of what I'm going to discuss. First, maybe discuss more the issue of countries that are maybe not directly affected by an armed conflict, or where the armed non-state actors labeled as terrorists is based. This would open a big scope also because in many of these countries the laws that can affect humanitarian actors are not necessarily part of a CT laws. For example, I don't know, in Colombia, to take an example that you also know, where we as Geneva Call also have been affected, there is a prohibition to have any contact whatsoever with what they call illegal armed groups, but it's not necessarily terrorist groups, so it doesn't necessarily fall into the scope of this discussion. So let's focus maybe on what one could call donor countries, mainly, or countries that are outside of where the conflict is taking place. So there are essentially two sets of possible impact, and I think one Ambassador Zellweger already mentioned quite extensively is the risk of criminal prosecution, so I'm not going to enter into this. I think he covered this aspect very well. So let me jump more to the financial implication that these CT measures can have. And what does it mean? Basically, mainly donors, of course, also don't want to be in violation of CT measures, or it's they're part of the government, they're state donors, but there might be also UN donors or big agencies that are also submitted to certain rules. So they want, of course, to be sure that the funds they give to humanitarian organizations don't end up giving material support to an Arnold State actors that is labeled as terrorist. Therefore, they take a number of measures that in the end are affecting humanitarian action. For example, some donors are refusing to give funds for activities in territories controlled by a certain Arnold State actor, or they ask for always more complex requirements of guarantees that nothing from the humanitarian aid does at some point trigger to the Arnold State actors. And we know that in practice this is impossible. We cannot guarantee that if we make food distribution. I mean, who knows that the elderly lady to whom we have given a bag of rice is not also giving some rice to her grandson that happened to be part of a terrorist group or group labeled as such. And also they are requesting always more information. So, but who are the beneficiaries? So some humanitarian actors have to or are asked to give full lists of all the people that they have given support to, and there is, of course, there were a problem with regards to the protection of information for this person, privacy, also with regards to principled humanitarian action. And it can even go beyond, so there are sometimes clauses in certain contracts that we have not necessarily directly faced as Geneva Call, but for example, UN agency have mentioned that they have been faced with clauses that say you commit to support the fight against terrorism, but there is a real problem with regards to principled humanitarian action. Precisely, principled humanitarian action implies that one is not participating in any conflict, in any political question, that one is neutral and impartial. So if one is committed to a fight against terrorism, that goes clearly against principled humanitarian action. So what are the consequences of all that? So on one hand, there is of course an increased administrative burden for humanitarian actors. Which on one hand one could say, okay, it's also positive. I mean, every humanitarian actor has an interest that the funds are used really for the civilian population that needs it, and it's not diverted for other purposes. Also, not necessarily only related to terrorism, but to fraud in general or criminal activity. To be accountable to how they use the funds, also with regard to their own beneficiaries. And of course, to assure they are respecting humanitarian principles. But on the other hand, sometimes the administrative burden starts to be so big, and they know they will not be able to comply with all these prerequisites, that they would simply not conduct certain operations. It's okay, it's not worth trying to go, I don't know, to Al-Shabaab controlled area, because it would be so complicated. We would need to comply with so many requirements that it's better we don't even start. So let's go somewhere where we know we will have less problems. So there again, we see ourselves faced with part of the civilian population that will maybe receive less aid. There is also an issue of reverting the risk to local partners. So one imposes always more burdens on them. They have to check, they have to make sure. I have found a clause with the local partners that we have, that they received a contract from another humanitarian agency where they had to commit that they would have no relations with any Arnold State actors listed as terrorists, and this was in Colombia, when we know this partner works with us. And our task is to talk with the FARC and with the ELN, and they are those listed as terrorists. So obviously, they cannot respect this kind of clause, and it also doesn't make much sense. But then we overload also these organizations, which often are small, don't have necessarily the capacity, and are anyway already exposed to more risk be it from our non-state actors on the ground, be it from the states and from the conflict itself. There has been a very interesting study made in 2013 by OCHA and NRC that have tried to document the impact that CT measures have on humanitarian action. They concluded that it was difficult to say really, or to be able to prove that CT measures had deteriorated the situation of the civilian population, because of course there are so many different factors that it's difficult to know. Is it a conflict that maybe was more tense, or there was a drought? There are of course many factors, so it's difficult to say, okay, we can scientifically prove that CT measures have affected the well-being of the civilian population. But when it comes to conducting humanitarian actions, they were clearly able to prove the impact. They looked particularly at Somalia and at Gaza Strip in Somalia. Clearly they found evidence of massive reduction of funding for Al-Shabaab controlled territory. In the Gaza Strip also there were similar findings, and especially one of their very disturbing findings was that there were still some humanitarian actors, of course, present in Gaza. There still are. But then that many of these actors would try to design their humanitarian program, not necessarily according to the needs of the population, but sort of in order to avoid any kind of contact with Hamas. And to a level that was there was one case that they were mentioning of humanitarian workers walking out of the room when there was somebody from Hamas coming in, because they were so afraid that they could sort of then face a criminal prosecution because they were sort of eye to eye with somebody from Hamas. And this, of course, does affect, and I think there to reconnect with the opening words of Ambassador Zellweger, that with the issue of principled humanitarian action, and I think this is a very worrying trend, and it does also then reversely affect humanitarian actors in the sense that, for example, if we go back to Al-Shabaab, then they expelled humanitarian actors, among others, not only, but among others, because they said, oh, but you are participating in all these CT measures, you are not giving help to this and this population, so you are not neutral, you're not impartial. So we want you out of our area. So this issue of principled humanitarian action is not only an issue of to be moral and to behave properly. There is, at the end, the consequence is that humanitarian actors would end up discriminating against certain part of the civilian population, which is in contradiction also with IHL, and they occur also massive risk against themselves because they start to be perceived as being part to the conflict or supporting more one part to the conflict. Maybe a couple of words briefly on Geneva Call, if you allow me.
Yeah, sure. Because we have to open the floor to questions and comments.
Yeah, exactly. So I will try to be extremely brief. So we have been lucky. Until now, we have not been much affected, and actually, it's quite interesting that an organization with primary mandate is to engage with our non-state actors, among them some listed as terrorists, would not be the primary target of CT measures. Maybe there have been more worries with regards to assistance more than protection, but at least we have until now be rather lucky. Nevertheless, there has been consequences. There have been donors who said, "Oh no, we don't fund you in Colombia because you engaged the FARC and the ELN." There has even been, for example, banking services who said, "Oh, but we thought that there is a member in your advisory board that is a listed terrorist." In fact, he was not. But so these kind of things come up. There is also staff members that say, "Oh, but I want afterwards to work in the US, so I don't want to have Geneva call on my CV. I could be arrested. Also, a US law firm that first wanted to work pro bono with us, and they no, better not. Additional donor requirements with regards to how we are choosing our local partners, but there we have a problem because precisely sometimes we do on purpose choose local partners close to certain armed non-state actors in order to conduct indirect engagement, and they help us in our advocacy work. So until now we have not been much affected, but it is still a sword hanging above our heads, and we never know when suddenly something could backfire. And I will close there.
Interesting, thank you so much. What you said also rings a bell to what we have situation in Syria today, where UN is not getting in with any humanitarian aid. It stopped everywhere because the different parties say no, otherwise it will reach our enemies, which are terrorists. So they use food and medicine like a weapon of war. Now, I would like to open the floor to reflections and questions on these very interesting points that we heard from the three speakers. So feel free, please introduce yourself, and if you would like to stick to a question, keep it short so we have time for many. Please go ahead.
So I'm Clémence Boutanville from NRC, and I just wanted to compliment on what you were saying, because I think as an operational organization, I think a very important one is to understand the legal framework in which we are working and the counter-terrorism measure. So following the impact study we did research on in 2013, we also published a risk management toolkit in relation to counter-terrorism measure. So trying first to provide some overview of all the policies, counter-terrorism measure framework, so that our peer organization can also find their way in this, because I think we don't always measure the consequences of, sometimes we just refrain from acting because we don't understand what will be the consequences. And the second part of the risk management toolkit is about giving an overview of existing risk management tools that are used across the sector. And for us, it's very important to continue this work to collect evidence of the impact of the CT measure on principal humanitarian action, to train our peers to continue this dialogue, and also to lobby with the states and the UN, because they are the ones who are giving these restrictive measures. So that's that's a hot topic, as you said in the beginning, and we're not going to finish it soon, I think. But NRC really is committed to,
especially collecting documentation.
Yeah, exactly.
Very important for a future.
Yeah, measuring the impact, working on risk management framework, and also training and raising awareness among frontline responder, because I think also sometimes operational organizations, a lack of They don't know, and they don't have the staff to train. So that's a collective work, I think.
Anyone else who has a question? Yes, go ahead, please.
Good evening, I'm Anna, and I would like to ask you, I would like you to be honest, if you think that the state parties will reach the states will reach the agreement to finish the treaty on terrorism.
Voilà. The three of you. Start.
It's very difficult if you ask me to be honest. I was involved in these negotiations because I served in New York when the United Nations did indeed adopt a series of counter-terrorism conventions that have been mentioned by Sandra. On the comprehensive one, I am pessimistic, and this for two reasons. First of all, as I mentioned, 9/11. At the time of 9/11, and you remember that was happening in New York, that was the time to finish the comprehensive convention. And it wasn't done. We were negotiating it. We had a meeting on the Comprehensive Convention in October 2001. That was the moment we should have done it. And it was not possible because of the definitional issue that has been mentioned. And there is this famous formula, my foreign fighter is your terrorist. It's very difficult to get around this issue. I think that I entirely agree, we do not have a definition in international law of terrorism, but we find what I would call traces of a definition. If you look, for example, at the Anti-Financing Convention, you do have elements. You also have elements of a definition in the first edition of the Special Court for Lebanon, where Judge Cassese came up with a quite comprehensive definition of terrorism. It is possible. The interesting thing in the definition that is contained in the Financing Convention is that it's centered around the intimidation of the population, because that, in the end, is the ultimate goal of terrorism. Whatever you do, and I agree that probably we would have to talk about the means, but the intention is to intimidate a civilian population. So if there was the will, I think we could come to an agreement, but we don't, and I'm pessimistic. If we didn't do it in 2001, I don't see why we should be able to do it today.
That was an honest answer.
If I can say something, go ahead. Yeah, I agree with you. I think I think one piece, besides, as you said, there are traces of what can be seen as like the core of a terrorism offense, which is certain acts with intimidation of civilians, and it has also been used at least once in a Security Council resolution. But then, how can many states have much broader definitions, and that's where it becomes so problematic on a national level, that if you have these overly broad terrorism laws that then are systematically abused to target dissidents, to target minorities. And I think from that point also, it would actually be desirable to have a comprehensive convention, because it would give us like a clear standard saying, well, this is the definition of terrorism and everything else is too broad, but we're probably not going to get there. And it's the Security Council, whenever it takes measures that require states to take measures against terrorism, it has never defined so far what is terrorism, which then allows for this overly broad implementation in national law.
But I mean, sorry for a maybe stupid question. You said if we didn't do it then, 2001, we were not going to do it now. But isn't it more of an urgency to do it now than ever?
Of course, it's more urgent, but I entirely agree. The problem is that many governments, I think, have understood the beauty of not having legal restrictions. And it's much easier if you have the power to designate someone and to label someone as a terrorist than if you are bound by international law. And this is why I think, and I agree, I think the more we need it, the more it will get difficult. And you mentioned this example of a hospital that was bombed with the explanation that there are terrorists in there. Now, IHL is very clear on this subject. You do not bomb a hospital, period. Whoever is in there. If you say there are combatants in the hospital, that in itself will be a war crime to use the Red Cross emblem if you try to hide a military objective. But it's the labeling of a group that makes it so easy. And this is something that we increasingly see, that the labeling is used as a means to for politics, for political aim.
I think I understand. Sorry, in the back, please.
Thank you. I will take your example on Aleppo, and you mentioned almost always the blame is on states in the application of city laws. But don't you see that part of the problem is the selectivity on the side of UN and international organizations concerned with the issue in addressing questions of protection of civilians in situation of terrorism? And here I give an example of the war in Mosul, in which you have more than 1 million civilians. We know that the coalition forces attacked hospitals, and nobody mentioned that, not the media, even the Commission on Human Rights. In their statement 2 days ago, they did not address it as an issue of a crime. The same thing happening in Yemen or in other conflicts. So you see the selectivity or the politicization of the issue also is a hindrance to the application or to reaching agreement.
But just a very brief remark, and I agree that non-selectivity is impartiality is an extremely important principle. But I just would like to say that I participated in a briefing by the High Commissioner for Refugees this morning, and he mentioned Mosul under humanitarian aspects. So to label something as a crime is one thing, but the most important, and this is also what we've been addressing here, the most important is the humanitarian issue. And to what we know, the humanitarian issues, at least in Mosul, are very much on the radar of the international community, and certainly also in Yemen. But you know that Yemen is an extremely difficult region to access.
But the media does not mention it, the concerned parties do not mention it, so I think that's hindering reaching agreement, because the states feel that there is double standard in the application, sometimes.
But again, I think it's very important to distinguish. The media is one thing, and frankly, as a representative of the government, there is not that much that we can do to influence the media. I think that would have to be done directly in contact, and you should talk to Gunilla.
Yes, and I see what you're saying, but I have to defend us.
But again, when it comes to government, and that is something that is very important for my government, impartiality, and there I entirely agree with you, impartiality is the bedrock of humanitarian action.
Very true. And when it comes to the media, I think we reported in case of Yemen, it's a very good example, because there, for example, the Saudi-led coalition, they were on the blacklist, and they were actually pushed off the blacklist by Saudi Arabia, and that we reported extensively, because that is, quite a big scandal, I think. So, please.
Yes, thank you. My name is Yahya. I'm from the mission of Iraq here in Geneva. So I have a short comment about the question raised about the challenges in this engagement in counter-terrorism. So in Iraq, the terrorism hit Iraq since more than 10 years. So we see the terrorists between time to time changing their plans when they hit the civilians. For that, the government, I see, because I was living in Iraq, I see the measures and the plans and the laws change between time to time. So if you don't change your local measures or local legislations, the casualties will be more. So this is the first one. The second one about Mosul. Also, there is a question about the actions the Mosul battle was very different, because there is a preparation for this operation. They announced about it before months. So they put plans. There is coordinations with the humanitarians actors after the liberation. So also there was many plans, like they put instructions and by the airplanes to the people how to go out, about the safe exits, and many measures. Personally, I talked with some soldiers there in Iraq. They told me there is very difficult things there in the engagement, how to decide for example, when someone coming to them, how to decide if he's running from ISIS or he's coming to bomb himself. So it is very, very difficult thing for them. But in Mosul, they consider all these things. They put instructions, and the operation is going well. So, and achieving its goals without any mistakes. Thank you.
Yeah. Would you like to comment on this? Or otherwise, we're going to take one last question, I think, because it's already 2 o'clock. So, I see many hands. Ooh, okay, please go ahead.
Okay, my name is Maywen. It's very interesting what Sandra mentioned about the implications of like the city laws on human rights in general. And you mentioned what's happening in Syria and how the city laws are being used to block refugee movement. I've seen also in Nigeria, in northeast of Nigeria, where the government treats the Boko Haram as terrorists, and how the preferential way of treating people who are actually affected by the conflict, like targeting certain communities on the basis that those people might be, those ethnicities or those tribes must be linked to the Boko Haram, and arresting them for a long period without access to justice at all. Do you think, from your perspective, that, I mean, apart from the international CT convention that we've been waiting for a long time, is there anything else that can be done, like another track that can be taken to make sure that civilians are protected in this kind of situations, and not relying so much on the international conventions that are totally extremely politicized to achieve?
Well, I don't think it's not the international terrorism conventions that address these issues per se. Then I think it's really would be much more question of human rights law and refugee law. And I think you're right that we face significant challenges in and implementation of these on a national level and all over the world. So what else can be done? I think there are various ways of pressuring. But if we see how it develops all over the world, I think it's going to be a difficult time in Europe, in Africa, in the US to make sure that, because legally it's very clear, and Ambassador Salvador mentioned that there is nowadays, contrary to 2001 when it wasn't that clearly acknowledged, nowadays it's clear that in the fight against terrorism, international law must be respected, and that covers human rights law, IHL, and refugee law. So legally there is no longer a problem. It always comes back to the implementation and actual application then.
But there were starting to be also certain steps, and if you go at the national level, but also, for example, EU level, when we talk about counter-terrorism laws and measures, they start, or even in the US, they have enacted sort of also a new law that's supposed to be more precise of what it means, material support. So there are certain tendencies that go into the right direction also at national level. So the international level, of course, is not the only one. But what is extremely important at what level ever measures are taken, if national or international, is that principled humanitarian action is not impeded, and particularly the engagement with our non-state actors. Because as it was already mentioned, if there is no dialogue possible with these our non-state actors, they have no incentive whatsoever to improve their respect for IHL.
If we're now very disciplined, last two people who wanted to ask questions. Please go ahead.
Thank you. So briefly, can IHL practitioners or organizations be more assertive or proactive in tempering the extreme political reaction that CT measures often invoke?
Can or should? Well, can, I don't know. Should, yes. And I think that's the important political message. They should do so. If they are ultimately successful, we will see. But I don't think that's a reason not to do it. We have to do it because, and I mean, I'm not going to repeat all the reasons. But one of the main reasons is that if we don't do it, we undermine the very foundation on which IHL is built.
And I think to add on that, as a representative of a humanitarian organization, I think one sees a trend, and I think NRC has been very much leading the ways among other actors, but there is an increased trend of trying to address the issue. You will correct me. In the beginning, there was sort of a bit, everybody's on its own. I am below the radar. I negotiate on my own with certain states and donors, and I don't tell anybody what I'm doing. So I will not be affected, and the others will see how they survive. So there was a certain tendency to that, and I think now we are more and more, we see coordination, discussions among humanitarian actors to see how we can move forward. Of course, there are difficulties also, as Ambassador Zellweger was mentioning. What do we do with the exemptions? not all the humanitarian actors necessarily have the same view. Do we want exemptions for humanitarian action, or do we say, no, this is not necessary, IHL and human rights law is already precise enough, but that we talk and we try to coordinate itself is already very important.
Yeah. And so, go ahead, last question.
Thank you for fitting it in. Louis Hoffman from IOM. My question's about the designation process, the listing process. And I guess in the absence of a comprehensive convention, are humanitarian actors left to look at the designation process for guidance? And what does that process look like from a legal or a political standpoint, particularly within the UN? They have a designation list, if I understand correctly.
Well, I think the problem with the designation process is both on the UN level and even more so on a national level. No, it's not strictly speaking a legal process. I mean, it's heavily influenced precisely by political considerations, so it's much more an administrative process. And I mean, within the UN, there has been progress made on delisting, that it's possible for individuals to be delisted, but that also is a bit, it reverses kind of the burden of proof, because first you're listed, and then it's up to you to make sure that you can be delisted. And on a national level, it's the same, and the same thing we have for the EU. And in the EU, you can challenge it before the European Court of Justice, and quite a few of the listings of groups have been quashed by the European Court of Justice, because they said, well, there actually wasn't sufficient information given to justify why not even a group in itself should be on the list. And there is very little, in the UN you can have the Al-Qaeda sanctions committees. There needs to be a link to Al-Qaeda, and then you can be listed. But there's very little, there are some very generic phrases what it means to be, but it's not very precise who exactly. And then it also means that, any other group that does not have links to Al-Qaeda is not on this. And you may remember that after the Beslan bombings, there were attempts to have another group that would have a generic mandate to list terrorist groups. They could never come up with either a definition of what is a terrorist group, which is also linked to the fact that there is no definition of terrorism, nor what other kinds of groups should be there. But then these groups we find on national levels, and you can find a lot of contradictions. And it's, as you said, it's one man's terrorists, is another one's freedom fighters.
Excellent. Well, thank you very much, Ambassador Zellweger, Sandra Krenman, and Carla Junta. It's been very interesting listening to you, and this topic will be around for a long time. It's very difficult, and we're all going to follow now what's going to happen to Donald Trump's waterboarding, aren't we? And I think last words will go to you. I just want to thank you all for coming here, and see you next time.
I forgot to mention it at the beginning, so I hope you don't have any problem with this. So there's people on the YouTube and on the Geneva Academy website.